Hi everyone, welcome back. I'm Brandon Silver, a construction, contentious and transactional lawyer. In today's vlog, we're diving into a topic that's important for both contractors and employers in the construction industry: delay and disruption claims. So, what is a delay and disruption claim? Let's start with the basics. Delay and disruption claims arise when a construction project doesn't go as planned. These claims are made to recover costs or time extensions when a project suffers unexpected delays or disruptions. In the UK, these claims are common and often complex, as they can be influenced by a range of factors, anything from adverse weather to changes in project scope. So, what is the difference between delay and disruption? It is very important to understand because they are not quite the same. So let's start with delay. A delay happens when the project timeline is extended. For example, if a contractor can't begin work on schedule due to late site access, that's a delay. Disruption, on the other hand, doesn't necessarily extend the project timeline, but impacts productivity. This could mean, for example, if access to parts of the site is restricted, which hinders progress on specific tasks. So that's the main difference. Now, both can lead to claims, a delay claim or a disruption claim, but they are measured and proven differently. So let's now talk about types of delay in construction. In construction, we classify delays into three main types. The first are excusable and compensable delays. These are delays caused by the employer, like late design approvals. In these cases, the contractor may be entitled to both time extensions, an extension of time, and additional costs, be it their loss and expense. The second type are excusable but non-compensable delays. These are usually external events like extreme weather or force majeure events. In these circumstances, the contractor may receive additional time, be granted an extension of time, but typically will not receive any financial compensation. The final type is a non-excusable delay. These occur due to the contractor's own actions or failures, such as not having enough manpower, by way of example. Here, the contractor would bear the risk and the cost of the delay, would not be entitled to any extension of time or any additional costs. So how do you prove a delay and disruption claim? Well, proving these claims ultimately, as I'm sure you'll not be surprised to hear, required solid evidence and often detailed record keeping. Here's a basic checklist. Number 1, documentation and keeping records of everything. You want to document everything. This includes contracts, schedules, programs, progress reports, meeting minutes, timesheets, site diaries, photographs, videos, communications. If you have all of that, that's going to really assist you and strengthen your delay and disruption claim. Evidence is key. Number 2, you will need to undertake program analysis. You need to keep detailed records of project timelines and track any changes against the original baseline program. Number 3, of course, is then quantifying the impact. If the delay or disruption has caused financial loss, you need to quantify that impact. This could include labor and material costs, equipment hire, and any other related expenses. You need to keep all financial information, invoices, timesheets, remittance invoices, because again, that will strengthen your claim, especially if you bring an adjudication where the adjudicator will need to see your evidence to support your claim. As I've therefore can't stress enough, you need to have organised records. It is the key to a successful claim, and I again refer you to my previous vlog where I stated what kind of information we're looking at. Now, I'm now going to talk about some contract clauses that you need to look out for, which is relevant when you're talking about delay and disruption claims. Many standard contracts in the UK, like JCT and NEC forms, contain provisions for delay and disruption claims. These contracts may specify notice periods for claims, types of allowable delays, and procedures for claiming time extensions or compensation. You need to always review your contract carefully to ensure compliance with these terms. If you do not comply with the contractual terms, then you may lose your entitlement. By way of example, I typically see an amendment to a contract, typically in a JCT contract, which states there is a condition precedent to an entitlement to an extension of time, that you've notified us of the delay as soon as reasonable and in any event within 14 days of the occurrence of the event. You therefore need to make sure you're issuing the compliant notices on time to avoid losing that entitlement. So, final tips for managing delay and disruption claims. Number 1, plan for risks, use a robust project timeline and prepare for potential delays. Number 2, communicate proactively. Open and regular communication with all parties can help resolve delays before they escalate. Number 3, and probably the most important, seek legal advice early. If you anticipate a claim, please do not hesitate to call me and I can help navigate you through that process more effectively, not only in making sure you've got the right evidence and building your case, but also ensuring you've issued compliant notices and complying with the contract provisions to avoid any argument that you've not complied with the contract and therefore not entitled to those time extensions / additional monies. So, thank you for watching. I hope that's provided some clarity on handling delay and disruption claims in the UK construction industry. It's obviously a very quick vlog, this one, and I've only not gone into it in significant detail. So if you have any questions or would like on this topic or any topic for that matter, then please feel free to drop a comment below. Also, again, please don't forget to like and share if you found this helpful. Thank you for listening.